Okay, well, the good news is that this is probably not going to take a whole hour, or how much we have left, 45 minutes. It'll probably only be about a half an hour. The bad news is, though, it's about case law. So they leave that till the end. And for those of you who don't know me, I have worked at the Indiana Public Defender Council off and on since law school, about 14 years. And part of my job there is to review every case that comes down from the Indiana courts, along with my coworker, who's actually my husband too, and every case that comes down from the U.S. Supreme Court. So for 13 years, I've just been writing these little paragraphs of every case that have come down. So I got all this case law in my mind that has to just keep coming out. So that's why this is what it's about. And I want to talk first about how experts can hurt us and how they've hurt me in court. And this is like an unfair hurt. This is not something that's fair. They can give opinions that only fuel speculation. They can talk for hours with pictures of gore behind them. They have this rationale sometimes, I know it when I see it. And you get that mostly from the police officer who says, I've been a police officer for longer than you've been around. I've testified 400 times, and I've been to 5 million crime scenes. That's the rationale for their opinions. And also you get the experts that fill in the holes for the prosecution. They're the hardest, I think, to challenge, and I'll talk a little more about that. Okay, this is my checklist, because I have a problem when I hear an opinion that's being given by an expert. All I can think of is, that's ridiculous. That can't be. You cannot say that. But that's not an objection I can make. So if I have this checklist here, you can quickly think about what is wrong with that opinion. Why is it ridiculous? You have relevance. Now in Indiana, it's Rule 401. And, we're in different states, but the ideas are the same. Unfair prejudice. These are all the limitations that there are on experts. They got to be helpful to the jury. They can't just talk about something the jury should know. They have to be qualified. They have to have reliable reasoning, which would be Daubert or Fry, and a sufficient factual basis. They can't come in and talk about, well, in my experience, I've interviewed all of these abused children, and these abused children tell me that it really, really hurts when I'm abused. So therefore, the child in your case was in a lot of pain. That's not a sufficient factual basis. They can't give their opinion on intent, guilt, innocence, truth or falsity, or whether the witness is testifying truthfully. And a lot of these experts come very close to this and sometimes overstep it. Now, whenever I make a legal challenge to an expert opinion, I start with the purpose of these rules. And the purpose of the rules is to protect against wrongful convictions. That's why they're there. And there's a lot of studies out there that help us, and I always put in a study when I can. And I got this study, I think, off of the Innocence Project's website. In a study of 86 wrongful convictions, 63% featured forensic scientists who were wrong, lying, or both. And that's pretty powerful stuff, because it gives the judge a purpose. Why are we challenging this? And what's the prejudice if it comes in that the guy's wrong and an innocent person's going to be convicted? And that's also the driving force behind the NAS report. There's a lot of great language in the NAS report talking about how DNA has opened up a new world. DNA now shows us that there's wrongful convictions, and a lot of those wrongful convictions are based on other forensic disciplines. The relevancy objection. This is the most overlooked objection, I think, out there. There's a new case in Indiana, and of course this is Indiana, but it can be used anywhere. And in this Deloney case, a hat was found at the scene. And the hat had a mixture of DNA on it. And the DNA analyst came in and said, well, Deloney's DNA may be included in the mixture. It may not be. I just can't tell, and I can't give you the statistical probability that it would be included in the mixture. But he is not excluded. Well, what relevancy does that have? And you're just basically saying maybe, maybe not. That is irrelevant, and it should have been excluded. So anytime in Indiana now that there's a DNA testimony, there has to be a statistical probability associated with it. Now, what's so great about that case when I see it, the same logic applies to all these other comparison type disciplines, like hair and fiber and shoe prints, maybe even blood spatter. But they can't tell you how likely they are to be wrong. So what's the probative value? If you can't tell me what your error rate is, or how likely that is my client's hair, then you're not giving me anything, and you have no probative value, and it's irrelevant. So I'd make a 401 objection to this type of stuff. And the NAS report says all this. It follows the case law, and I would encourage everyone to quote the NAS report when you're making these challenges. There they say that courts should not only consider the reliability, which we all know under Daubert or under Fry, but should also consider the subjectivity of a science. Because when you have subjectivity, you're going to have error and bias. Now, a lot of people too would think, what is the problem? I mean, I can cross-examine really well on someone who can't say that that is the person. You know, there's a big whole area of cross-examination. Well, maybe it's not the guy. You can't assure me it is. But the problem is that juries don't always listen. They get confused. Also, a lot of times they go with their gut. It's just who they like better. And there's some pretty charismatic experts out there. They're good testifiers. I mean, I put Dr. Phil in here because every time I hear something he says, I'm just like, what the? It doesn't make any sense to me. It doesn't sound very professional. I'm not a psychologist, but it doesn't sound right. But people love him. They buy his books. He has his own TV show. It's because he's a good testifier. I'd love to have him come testify for me. But it doesn't mean he's reliable. In civil law, I found civil law is wonderful, much more than criminal law, because everybody starts on the same playing field. And so people actually have Daubert hearings, things get excluded. And so there's great language in civil law. And here they say the risk that the jury will make an irrational finding based on the siren-like allure of opinion stated by highly qualified experts. That's the risk. That's the prejudice prong of what you call a 403 type of objection, where if there's unfair prejudice that substantially outweighs the probative value. This is where you get your language. More civil law. Again, here they talk about confusion of the jury. They say just exactly what I said, that if there's an unknown probative value, then there's this risk that the opposing party and the jury will be confused, and therefore it should not come in. Now, we're in a too dumb for Daubert state, and it makes no sense. If your expert is too dumb for Daubert, then he doesn't have to apply Daubert. It's exactly the opposite of what the NAS report says. So in this state, it's great if you claim you're not scientific. That's the smartest thing you can do, like hair, possibly blood spatter, but shoe prints, any of that. Because they're not scientific, then you don't have to prove you're reliable. That's too much. So there is no Daubert, no reliability, no Fry, none of that, if you are not scientific as an expert. And they're called skilled experts. Now, using the NAS, if you're in a too dumb for Daubert state, there's a lot of them too. When I went out to California and talked, they were a too dumb for Daubert state. And the NAS report says exactly the opposite. It says that these are the disciplines we should be worried about. Chapter 5 of the report, and I encourage you all to look at that chapter. That chapter pulls out maybe 10 of these disciplines. And they're all these comparison disciplines that aren't based on scientific reasoning. And they're the ones that are causing the problems. They're the ones that aren't validated. They're the ones who should be excluded. So the ones that aren't being that should be excluded are the ones in Indiana that you can't even get a hearing on. It's kind of like if all the kids in a school weren't passing the test. So what do? You just make the test easier. So I would cite the NAS report if you're in one of these jurisdictions as to why you need to change. Because again, as Christine said, the NAS report reflects the scientific community. And if the scientific community believes that technical disciplines should be just as reliable as scientific disciplines, then so should the courts. Now, the reason I put the too dumb for Daubert in here too is because that brings us back to the relevancy challenge. If they are not going to change the law, you can get to the same point by doing a 401, 403 type of objection and analysis by talking about the subjective nature. It lacks probative value and it should be excluded under Rule 403 because it has too much unfair prejudice and too speculative. Now, I put a little test up here. In this case, it's been a little while since I read it, but let's just say your client, Reba McEntire, let's just say, is sitting next to you, and she's on trial because her boyfriend was in the other room, and her boyfriend battered her child, and her child died. And you're having your their forensic pathologist gets on the stand, and it's testifying about the injuries. And the injuries are really bad to the child. But your defense is that I didn't know. How could I stop him? I had no idea what was going on. So you're listening to your forensic pathologist, everything's going all right, and all of a sudden, she says, I'm a child abuse expert. And I've interviewed 5,000 kids that have been abused. And they tell me how loud it is when they're abused. So I believe there's a high probability for these injuries to have occurred. The person in the other room would have heard it. Well, you just got screwed. The state had filled in the blanks of their case by a pathologist where you never thought it would happen, because your case wasn't that the injuries didn't occur or didn't occur the way they said, just that you couldn't hear it. And the pathologist had just went and filled in the holes for him. So what is wrong with this? It could be a 702B. What's the reliability? I mean, where's the reasoning? Where's the scientific studies? We take kids in the other room and beat them, and we yell, hey, did you hear that? Can you hear me now? I mean, there is no scientific studies to support that. So it can't be reliable. It's beyond that pediatrician's expertise. I mean, again, does she beat children in one room and then, hear what happens? You don't learn that in medical school, how loud it is when you beat someone. I don't know what expertise that would be under. And also, she didn't have a factual basis. And this is everything that came from the Kentucky court. I mean, they might have used different rules, but it's the same idea. There are the 3 reasons she shouldn't have testified to this. She interviewed a bunch of other kids. That's not the kid in your case. She had no factual basis to make this. And I draw attention to this, probably because I'm still angry at this particular pediatrician or pathologist or whatever she is, because she did the same thing in my case, the same very thing. And you don't know what's coming till you're there. So you have to be ready for it and be prepared. In my case, the issue was whether the child was molested, and the child was killed. So she had been murdered. And she said, of course, the Dr. Spivak, that the kid had been molested. And we had an expert who said she wasn't, because there was some trauma to her genitalia, and it was all about that. But the real issue in the case was that the state made the molest the motive for the murder. They said because they inferred my client molested her, and that the daughter told the mom, and the mom was going to leave, so therefore my client killed them all, so that wouldn't happen. But there was no evidence from the daughter or the mom that anything was wrong that day. It was a perfect day. So as this expert's testifying about her belief of molest, which we knew it was coming, she slips in that she's interviewed lots of kids who've been molested, and they all go to their mom. So it's highly probable this little girl told her mom. How'd this happen? And the only thing I could think of at the time was speculation. You just jump up. That's what you always say, speculation, speculation. And it did preserve the record when really it should have been more articulate, these 3 right here on the screen. Now, reliability challenges. You do have, the 702B in Indiana, it's called reliability. That applies Dauber, and then you do have Fry challenges. But first of all, you got to get a hearing, and Christine touched on this a bit. In our state, and I don't know in many of your states, there's a thing called judicial notice, that if there's a prior case saying that this area of expertise is reliable, then so be it. We don't want to hear anymore. It's like what you say to your kid, I'm done, I've heard it, no more. And you have to get around that. And the NAS helps us get around that. And they say, just because a forensic science technique has been relied on for years does not justify its admission. And I picked this guy down here with the leeches. You go to your doctor, and he says he wants to cure you this way, you're not going to say, well, they've been doing it for years. Go ahead. So if you get yourself a hearing, these are the steps that I have created just to help myself. Because the hearing I did, well, one of them on Daubert was a blood spatter. And one of the state's experts gave a 9-hour deposition. How do you figure out what to challenge from a 9-hour deposition? First of all, you got to identify what is the scientific inquiry that you're challenging. What is the issue here? In our case, it just happened to be, how do you distinguish a few small stains on fabric from HVIS or backspatter or contact? That was the issue. And you have to decide what kind of challenge are you making. Now, are you making a general challenge to the overall type of forensic discipline? Was I challenging all of blood spatter? That would be hard, because then we have these prior cases where they've already said it's reliable. So I get judicially noticed out. So I don't want to go that path. I want to go specific. I want to say that blood spatter can be okay sometimes. I mean, you've got a wall full of tiny little stains. You know, chances are somebody did get beat in the head or did get shot right there. But in this case, when you only have a few stains, you're taking it too far. You're overstepping the scientific limitations. And that's a much easier thing to prove. I would not bite off more than you can chew. Just talk about your case and how that has gone beyond the science. I mean, you can do this with DNA. If somebody came in and said, this guy over here did it because the DNA was at the scene, not because the DNA matches him, but the DNA said that a short guy with brown eyes did it. Well, we know that's not right. Even though DNA is reliable, in this case it's not. So what you're doing is you're separating the good from the bad. Now, you can also do general challenges, and sometimes those are good things to do. In this same case that I'm talking about, I did one to a guy who invented a whole new area of expertise called materials deposition. And he could tell, because he was a material depositions analyst, that a little piece of tissue landed on my client's shirt from gunshot instead of contact. Now you ask him, does anybody teach materials deposition? No. Is there any type of publications on materials depositions? No. Any testing? No. So that was more of a general challenge to a newly created, just completely made up area of expertise. So once you identify what you're doing and what is the actual inquiry, you go to the second step and you identify what is that expert's reasoning. And this too can be really difficult. Why is that expert saying that the stains on my client's shirt came from a gun instead of contact? And this is especially hard when you have a 9-hour deposition. So the easy way out of this is that it's the state's burden. And you can file a motion for discovery. And in that motion discovery, you want to know what their expert's opinion is, what's his reasoning for the opinion, and I'd even go farther. I want to know the Daubert factors. What are the testing? Is there any publications out there that support his reasoning? Has he ever tested his reasoning? And have them answer them. I mean, if he can answer them, and there are publications that support him, there is testing, then so be it. You're going to find it out one way or another. But my guess is you're not going to get the right answers. You're going to get some publication that has nothing to do with anything, or they're just not going to answer it, as like in our case. They'll just ignore it and count on the fact that the judge is going to judicially notice that the whole area is okay. And then also you can always ask for a report. And in the NAS, they have a recommendation saying what needs to go into a report. But generally your reports are not going to be up to standard. I think asking for it through a discovery request will get you what you need. And this is going to cut back on the I know it when I see it. That can't be their answer in their discovery request. What's your reasoning? I know it when I see it. I've been to 4,000 crime scenes. The scene speaks to me. That doesn't work. And finally, that's when you apply either your Fry standard or your Daubert standard. And I have the Daubert elements here, or factors. Is it testable? Well, in this case, you can't shoot someone in the head and see what happens and wear a t-shirt. What they do is they shoot into a sponge and see what comes back. Well, a sponge isn't someone's head. I mean, it might give you an idea, but it's not going to get you to the point where you can look at a small stain and tell where it came from. So it isn't testable. Are there publications, error rate? In my case, there were 10 experts. 5 of them said it was contact, the stains on my client's shirt. 4 said it was impact spatter, and 1 said he didn't know. I mean, that's like flipping a coin. The polygraph is better than that. And do they have standards, and is it generally accepted? And when I say is it generally accepted, is the theory for distinguishing between these two things generally accepted? And these are all questions you can ask in your discovery and see what their expert has to say about it. And finally, if you find yourself in court and none of this worked, you got to keep those people on the stand, you know? That's all I can say. This guy right here, this is a real demonstration from a real case. And I'm not as familiar with the case, but I believe what's going on here is that the woman was being charged with killing her husband. And this dude found back spatter on her, which would make her the shooter. But the problem is it was on the back of the robe. So he got down off the stand and showed how that worked. And you have to keep him on the stand. And the way to keep him on the stand is to, first of all, explain how is the courtroom different? How is running around between a bunch of chairs different than actually the scene? It's going to be misleading if there are limitations at the scene that they're not in the courtroom. And you have to make a good record, and this is probably the appellate attorney in me. You have to make a good record of what's happening in front of you. You know, if you got a guy running around a bunch of chairs pretending to shoot someone, you can't see that in an appellate record. You have to take the time and tell the judge this is what's going on. And also you have the prejudice prong. Is this unfairly prejudicial? And there's actually a case in Texas where they've held a blood spatter expert can't get down and show the sequence of events. It's just unreliable. It's too prejudicial. And also the NAS report has a lot of good sites in there about limiting opinions. It's kind of like you can't say a match. You can't go too far with your expert testimony. And finally, you can get your own experts. And I would really like Quincy, because my husband has made me watch Quincy lately. He has all of them on DVD. And man, this guy does some good things. He's always fighting for the right person. And he doesn't take any crap from anyone. But if Quincy is not available, you can get your own. And I would suggest getting someone who actually helped with the NAS report, because that report's great. And if you can't afford somebody, they won't give you one. There's this case here that says the NAS report is a public record. And I actually looked at some of the cases that have been citing the NAS report lately. And there are all these Daubert challenges and Fry challenges, and 90% of them, as we would all expect, are being denied. But there's a consolation prize. The NAS report's completely admissible and fair game on cross-examination. You know, so it's not a great consolation prize, but it is a consolation prize. It is admissible, and you can use it. And I think you could even use it without an expert. And finally, we have all talked about the NAS report, and I think what it really boils down to are these 3 things. Because, you know, as much as we say you should buy it, and I think you should buy it, it's a bit boring to read from page to page. And this is what it reduces down to. 1, the bias. There's a bias when law enforcement become forensic scientists. And that's what happened. They move up the chain and they cross over from a detective to a firearms analyst, to a evidence tech, to a fingerprint analysis. And there's an inherent bias, and there's been studies done on this bias, and you can find the studies. And the NAS suggests that we remove law enforcement from the forensic discipline. And you can use some great quotes in there to keep this as your theme when you got law enforcement turned expert. The NAS also talks about educating analysts. Experience isn't enough. You got to educate them. So there's some good issues there for cross-examination. And finally, you got to validate. If that opinion is not validated by testing, then it's not reliable. So anything you got, you need to see if it's validated. For instance, in our case study, there is an opinion that a person wouldn't be, there's the opinion that a person would be hurt if they tried to do what the defendant claimed he did, tried to get in the house to save his kids. But where's the validation to that? There is no validation. So you have to be careful sometimes of where these opinions are coming from and challenge every single one of them. And finally, these are just lists of a kind of summation of how you can use the NAS report to challenge under Frye or Daubert, to challenge under 4.3 if you don't have Frye or Daubert, which is the prejudice prong, to attack qualifications, to limit demonstrations, cross-examinations, and to call your own experts. And here are a couple success stories where it actually has worked, where they've used the NAS report to make a Daubert challenge, and there have been excluded opinions. I'm sorry I don't have the cites to the first two, but they're in Kentucky and Massachusetts. They excluded an examiner's opinion that the knife matched what happened at the scene. I think there was a tire split. And then in the State v. Ward case, it's kind of a strange one, but they excluded a police officer's identification of drugs, as like the green leafy substance. I don't know if it was a green leafy substance or was it cocaine, but a white powdery substance as cocaine. They said you can't do that because there's no studies saying you can do that. There's been no testing. There's no error rate. How do we know you're right or wrong? And this is something that goes on quite a bit in our state, and it was excluded in citing to the NAS report. So, does anybody have any questions? We're all ready to go home? If that's it, thank you.